All right, it looks like we are live. Yes, we are. Okay, so welcome and thank you for joining us for today's webinar. My name is Santiago Marino. I'm a content creator here at DoorLoop, and we're going to give everyone just a few more seconds to join us. And while we get started, remember that this webinar will be recorded in case you want to watch it again, or maybe you want to share it with a friend. You can always find it on doorloop.com/webinars. Okay. Now, if you have any questions, please add them in the chat. We'll be happy to answer general questions. However, please keep in mind that we cannot give you any legal advice or financial advice. So if you do have specific legal questions, you can always reach out to our guest, Craig. We will share his contact information at the end of the webinar. So you can go ahead and reach out to him. And as you may have noticed, today we are talking about the state of New Jersey in particular. However, a lot of the information that we covered today may apply to other states as well. So even if you're not from New Jersey, you might want to stick around. Okay? Fantastic. And as you may know, DoorLoop is a property management software solution, and we help landlords and property managers manage their portfolios. And because we get so many questions about landlord-tenant laws, we decided to bring in an expert and real estate attorney. So today, we're super excited to be joined by Craig Rothenberg, a licensed attorney from the state of New Jersey.
Good afternoon, Santiago. Thank you very much for having me. Very excited to be part of this DoorLoop webinar. My name is Craig Rothenberg. I'm an attorney in the state of New Jersey. I'm also licensed to practice in the state of New York. I have an office in downtown New Brunswick. For those who are not too familiar with New Jersey, it's right outside of Rutgers University, where I went to college. I also went to Seton Hall Law School for law school. So I'm a Jersey guy through and through, for better or for worse, depending on your interpretation of that. So I've had my own practice for about 11 years now, and I've been practicing landlord-tenant law for about 10. That's not my exclusive area of practice. Originally I went off on my own with the goal of opening up a personal injury firm, but I very quickly learned in practice that it's hard to have one specific practice area, and you might need to diversify a little bit. So I started doing some real estate, residential and commercial, and then I started doing some landlord-tenant as well. And over the years, I've become pretty familiar with the New Jersey laws on the subject. There's a bunch of them, and it's pretty nuanced, and a lot of people have a big misunderstanding of a lot of the laws. So hopefully we could talk today, and if you have questions, I could clear some of those issues up for everybody.
Fantastic. Thank you very much, Craig. Appreciate it. Right. So let's briefly go over the agenda that what we're gonna be covering today, and then we'll go into each topic in a little more detail. We're going to talk about common landlord-tenant issues and laws, as well as grounds to evict a tenant. And we'll also touch on how to prevent delays or fines in the eviction process. After that, we're going to talk about the difference between hiring an attorney for evictions versus doing it yourself. And also something that is pretty important is we're going to talk about any changes that may have happened after COVID in the law of the state of New Jersey. At the end, if we have time, we'll talk about squatters' rights laws as well as rent increase laws. All right. So that being said, let's get right into it. Craig, can you give us an overview on the top issues that landlords and tenants tend to have in the state of New Jersey, legally speaking?
Yeah, sure. I mean, there's a bunch of laws that, as an attorney, that you have to be familiar with if you're going to practice in this area. The most important one is known as the Anti-Eviction Act, right? That's kind of our guideline for how do you go about the process of evicting or keeping a tenant. And then there's additional laws on top of that that are related. For example, there's a security deposit law that governs how you have to keep and return a tenant's security deposit. There's also an abandoned property law that in the event you lock out or evict a tenant, you can't just throw their stuff in the garbage. You have to properly notify them. There's a truth in renting law that governs some of the terms that need to be in a residential lease. So there's a couple of laws that you need to be familiar with. But really, one of the most important concepts that people who practice in this area need to understand is that just because a tenant is on a month-to-month lease, that does not mean that a landlord can just terminate the tenancy on 30 days notice. And that's one of the biggest misconceptions. I mean, Jersey is considered to be a very tenant-friendly state. I get a lot of phone calls from landlords who are just like, I don't like this tenant. I want to get rid of him. And his lease expires August 31st. Today's July 18th. I want to cancel it. I want him out. So I sent him a letter telling him he has to leave. And then I got to be the one who breaks the bad news and says, okay, well, I hate to tell you, but under New Jersey law, when the lease expires, that tenant becomes a month-to-month tenant unless you offer them a new lease. And that month-to-month tenancy will automatically renew every single month unless you have grounds to lock them out under the Anti-Eviction Act. So what ends up happening is you get these people who want to just get rid of the tenant on a month-to-month basis, but you can't do that. Now, on the flip side, the tenant is allowed to cancel on 1 month's notice if they're a month-to-month.
Oh, interesting.
Right. So the tenant can bail whenever he or she wants on 1 month's notice, but the landlord has got a renewable lease that they can't just terminate without cause, which kind of rolls into the next topic on the agenda, which is grounds to evict a tenant. Right. That's the big one. And how do you go about doing it? What's the right protocol for doing so? So the Anti-Eviction Act contains a list of grounds that you are allowed to evict a tenant. And they go from being pretty easy to be pretty challenging as to how you have to go about doing it, because they have different notice requirements. Let's start with the easiest one. The easiest one is non-payment of rent. Okay? Right. Tenant doesn't pay their rent. What do? They come to me. They say, what do I do? Okay, how much in arrears are they? From my experience, tenants, if they're usually in arrears 3 months or more, they're usually pretty unlikely to make it up. Okay, so gotcha. Usually right at about the 2-month mark, I say you might want to file now. And non-payment of rent requires no notice at all to the tenant. It is simply a complaint for eviction. You put down how much rent is owed. The court's going to establish a trial date for you, and the tenant's going to show up. Now, well, maybe the tenant doesn't show up and you get default judgment, but let's talk about a couple of the issues. One question is, they always say, well, can I include late fees and your attorney's fees? Right?
Yeah, that's pretty often.
Yeah. Because if the tenant's rent is $1,500 a month and my legal fee is $1,000, now all of a sudden the landlord's like, well, now I'm paying your legal fee. Can I get it? Right? The answer to that question is this, right? The tenant's lease has to contain magic language that states specifically the late fee and the attorney's fees can be charged to the tenant, magic language, as additional rent. Due and pay with the rent. So landlords come to me with clauses in their lease that says there's late fees or that says there's attorney's fees. But if it does not contain the magic language that they are included as additional rent, you can't include them in the eviction complaint. Okay, so that's the first hurdle you're looking at. Now you put down the amount that's owed. Okay, your landlord gives you a ledger showing you what's owed. You attach that to the complaint. Now there's a trial date that the court sets. Okay, and at the trial, a couple of things are going to happen. Okay, number one, if the tenant shows up with every dollar that is owed, landlord has to take it. Okay, landlord takes it, right? If my complaint alleges $3,000 in arrears, that includes late fees, legal fees, etc., tenant shows up with $3,000, landlord has to take it. In fact, landlord has to take it as late as 3 days after a lockout. You could complete the entire eviction and the tenant can show up to court and say, hey, I got the money, let me back in, and they're back.
Wow.
Right? So, yeah. So that's one way it goes down. That is not the way it usually goes down.
Gotcha.
Right. Now, another way it goes down is, let's say the tenant says, all right, I'm interested in settling with you. I want to avoid having an eviction on my record. And there's two ways that they usually get settled. One is what's known as a consent to stay agreement, where the parties both agree. They say, listen, you're in arrears X amount of dollars per month. We will enter into a payment plan where your rent payment, let's say you owe $1,000 a month in rent, your rent payment continues to be due on or before the first of each month, but then you're going to pay, let's say, $500 a month in arrears that's going to be due on the 15th for 6 months until you pay off that $3,000. Okay? Now, what that does is it gets you, the tenant avoids an eviction on the record. The landlord has a consent agreement acknowledging the amount owed. And if the tenant violates that agreement, the landlord simply files a certification saying the tenant has breached the agreement. Please issue the warrant, and you start the process of locking them out. Okay? So you're giving the tenant a chance to make it right, and it's up to them whether they can comply with the agreement or not. And, I go to court. I'm speaking a lot from the landlord's perspective, but I represent plenty of tenants as well. But from the landlord's perspective, you go to court, you're giving the tenant a chance. And I always, when I represent landlords, I tell the tenant, if you're going to make me a promise as to how much you're going to pay, make sure you can keep it, because I don't want to lock you out. I don't want to see you back here. Some of them bring their kids to court. I don't want to see you out on the street. Tell me for real how much you can actually pay and what's a realistic payment plan, because don't promise something you can't keep. Because once you agree to that consent agreement and you don't keep it, you're probably getting locked out. Now, the other thing that tenants sometimes do, by the way, I know I talk fast because we got a bunch of, so if at any time you want to interject with a question, just let me know and I'll pump the brake.
Sure thing. Yeah, no problem. Absolutely. You're doing perfectly well. If I don't interrupt too much, is because I want to make sure that you send your entire point across. And
sure.
So yeah, please go ahead. Take your time.
Right. So So just to backtrack where we were in this monologue, we're in court now for non-payment of rent, and the tenant has not shown up with all of the money, and the tenant has two options to settle: a consent to stay, and then the other option they could do is what's known as a consent to vacate. Okay. And in a consent to vacate, they listen, I know I owe the money. I need a month or two, right? The rental market's hard right now to find a place. Can I have some time? And usually what we say, listen, you owe us back money, but if you pay your rent for the rest of this month and for next month, we'll let you stay another month or two, whatever it is, as long as you agree to leave. And then if they don't leave in time, you just file for the warrant and then they're out.
Got it. So that could be like a first route before the second option, right?
Right. Well, the consent to vacate is just if the tenant's like, listen, I'm never going to be able to pay this debt, or I want to leave also, right?
Got it.
The one thing in landlord-tenant court is you don't get money in the landlord-tenant court unless the tenant shows up and pays you the money. But money is not a remedy that the court is allowed to grant in New Jersey landlord-tenant court. The New Jersey judge in landlord-tenant court either says evicted or not evicted, judgment for possession or no judgment for possession. If you want your money, you have to sue a second time in civil court. So the consent to vacate basically puts the civil claim on ice and just says, listen, let's deal with the eviction now. You're leaving. And then if you want, the landlord may go after the tenant later and sue them for the money, but that's to be decided later. Okay?
Got it.
So,
Yep. Yeah, so for a landlord, that might be a way to go if you just really want the people out, right? If you just don't want to deal with the problem anymore and you're willing to take, let's say, a loss by letting them live that extra 1 or 2 months,
Well,
right?
ideally you mitigate that loss by just saying, listen, I know you owe me a lot of back rent, but pay the rent for the time that you're here, this extra time, right? Let's say today's July 18th, we're recording this now. So you owe me, let's say your rent is $1,000 a month, 12 days, prorated, let's say $35 a day, pay me whatever that $400 is, whatever, my math isn't great, but pay me the $400 now and then pay your $1,000 by August 1st, and I'll let you stay until August 31st. And if they miss either of those payments, there's also, you can include a clause, now I can lock you out. So,
That's it.
right, that consent to vacate, sometimes the tenant doesn't want the eviction on the record, landlord may be feeling sympathetic, maybe the landlord doesn't want to spend the entire day in court, because the alternative now is trying the case, okay? So now
Uh-huh.
let's talk about trying the case.
Right. Yeah, I think that's what is the typical eviction process would look like, right? Is
Right.
that,
Right.
yeah,
So
I'll touch on that.
there are really two main defenses to a tenant in a non-payment of rent case. The first defense is I paid the rent. The math is wrong. Right?
Right,
Like
right.
I have a Cash App or I Venmo or I paid you with these receipts. Here are the pictures of my receipts. Here are my screenshots. Your ledger's wrong. Fix it. Now that we may have a trial. Judge looks at it, evaluates the ledger, has both witnesses testify, and says, "Okay, tenant doesn't owe any money," or tenant doesn't owe $3,000, they owe $1,000, and then the tenant comes up with $1,000, and the case is dismissed.
Got it.
That's one defense. All right, the math
Mhm.
is wrong. I paid. The math is wrong. The second defense concerns the habitability of the premises. Right, basically saying I didn't pay the rent because the property is uninhabitable. The property is in deplorable condition. The landlord is a slumlord. That I haven't had heat in a week. I haven't had hot water, and that's why I'm not paying the rent. So how does that go down? It goes down like this. The tenant needs to notify the landlord in writing that there's an issue at the property. It has to be an issue that affects the habitability. It can't just be like, oh, there's some cracked sheetrock here, and I don't like the
Right,
way it looks, right? It's
right.
got It's got to be real stuff that affects the habitability of the unit.
Because that's an unwritten law, right? Technically, it may not be in the contract, but the unit has to be habitable,
There's
right?
an implied warranty of
Imply
habitability
warrant.
every lease, no matter what, right?
Right. Mm-hmm.
A lot of the leases even have them, but it is implied. It must be habitable.
Uh-huh.
Now the tenant gives the landlord notice. The landlord, let's say your heat goes out. Your landlord must act reasonably given the emergent situation on hand. If it's the middle of winter, you want your landlord calling someone ASAP. But at the end of the day, right? But at the end of the day, you got to do your best to get a contractor there, but it's only subject to who's available. Now, what happens is if you have the landlord who is not responding, okay, or
Uh-huh.
you have the landlord, and this is one of the biggest mistakes landlords make. They say, well, they're behind on their rent. Why do I have to fix their unit? And I got to read my client the Riot Act and say your obligation to maintain the unit is not tied to their obligation to pay rent. So here's what needs to happen. The tenant now says, I've given you notice that you're not properly maintaining this place. You haven't fixed it. I am not paying you my rent until it's fixed. Okay. Or
Right.
I am getting my own HVAC guy who's going to come to the house and I will pay the service technician, show you the receipt, and I'm subtracting it from my rent.
Right. Yeah, I've heard of that.
Now what happens? The judge will say to the tenant, okay, you owe, let's say, $1,500 that you claim you didn't pay because of repairs. Theoretically, the tenant should still have that money. right? The tenant didn't pay the rent, was withholding the rent. So the judge will say, you got to put your money where your mouth is. The judge makes the tenant deposit that money with the court, and then the judge schedules a trial, usually about a week later. It's what's known as a Marini hearing. It's the famous case in New Jersey. It was the Marini case.
Gotcha.
Right? They'll hold a Marini hearing, Marini, or a habitability hearing, where the judge will determine what amount was properly withheld by the tenant, and the judge will then take the money that the court is holding in escrow, will release some or all of it to the landlord, or will release some or all of it to the tenant, and then the case is over. So,
gotcha.
That is my best 5 to 7 minute summary of a non-payment case.
Excellent.
Typical non-payment case.
Excellent. Yeah, it makes a lot of sense. And tenants have to have that money ready, right? Like, because a lot of people may just not pay, but if it comes down to it, the judge will ask for it. So if you've been holding it, you better have it.
Now, the judge will not ask for it if you show receipts. Like, for example, I paid the technician the $500. That's why I don't have the $500. So the judge can order less into escrow. But yeah, I mean, that's the way the average non-payment case goes down. You either look, half the time the tenants don't show up and you get judgment by default. That happens a lot too. So
I bet.
Yep. So
interesting.
Okay. So now that's your most basic, that's your non-payment case. Now there is a long list of of different ways to get a tenant out. Now let's go with the next most common example, okay? It's either my tenant has unauthorized pets or my tenant's a huge pain in the ass, right? Those are usually your most common other reasons that I see. Or the tenant's driving everyone nuts, or the tenant's always late with their rent payments. Okay. Now, each of those grounds are separate grounds in the Anti-Eviction Act for how you're going to get them out. But there are certain notices now that the landlord needs to send to the tenants that are different from a non-payment case where you don't have to provide any notice. Let's start with a lease violation, like pets, for example.
Right.
There is a clause in the Anti-Eviction Act that a lease can be terminated for ongoing lease violations. But what needs to happen is the first step in the process is the landlord has to serve the tenant with what's known as a notice to cease. And that is a formal letter that says, knock it off, right? It says, and it has to be very, very specific in terms of the behavior that needs to stop. Paragraph 7 of your lease contains a no pet clause. I visited your property and saw dogs on the property. You are in violation of your no pet clause. If this continues, we will take steps to terminate your lease. You are hereby ordered within 10 days to remove the pets from the premises. Okay. Now, the next step is 20, 30 days later, the dog is still there. The landlord needs to send a second notice that's called a notice to quit. And that now says you have failed to comply with our notice to cease. We are now terminating your tenancy at the end of the following calendar month. You have to leave by August 31st. Just picking that date arbitrarily. You have to leave by the end of next month. And then if the tenant does not leave, at that point, you can file for eviction. It's the same thing with a habitual late payment, right? If tenant's always late, you got to serve them a letter saying you're a notice to cease. You're always late. Stop being late. If they are late again, you serve a notice to quit, and then you file a complaint for eviction. Now, based on the timeline I just told you, when you have this situation where the landlord wants to get rid of the tenant for these reasons, it takes 4 to 6 months, right? Because if you do the math, if you do the math on the notice to cease, you're looking at a good month, another month to 2 months on the notice to quit, and then you have to first file for eviction. So by the time you finally get into court, you're probably looking at 4 to 6 months before you're going to see a judge. habitual late payment, from my experience, almost never works. If you serve the notice to cease and the tenant sends their next rent payment in on time, the notice to cease is garbage, and you got to do another notice to cease later. So I get habitual late payment landlords all the time, and I just say, look, man, you're getting paid. I know you like it on the 1st, but if it's coming on the 10th, you're getting paid, just take it, right?
Yeah.
It's just not practical.
Makes sense, yeah.
Now, and we're not going to get into every ground for eviction, because we go on. But now let's go with the more extreme situation, which is now you have a really disruptive tenant who is either breaking the property or causing major disturbances in the premises, intentionally or gross negligence in destroying your property, right?
Wow.
And I'm not talking about sheetrock, but I'm talking about, sometimes I've seen cases where the tenant hates the landlord and they'll flood the bathroom on purpose. Right?
Well, I'm sure that happens.
Yeah,
they'll put something down the toilet. They'll put in chains? I don't know, ropes.
Great. Well, the wipes thing, I get the wipes thing all the time, and that's the gray area where they're like, well, they knew they couldn't do flushable wipes, and then and they did it, and then you got to tell them, listen, I've clogged my own toilets because kids put flushable wipes down in. Right. You're not trying to destroy the property, so you're not going to get intentional that way. But in the intentional situation, that rare situation, you can skip the notice to cease, and it's a 3-day notice to quit and then file. So if you get that really, really bad tenant, 3-day notice to quit, file, and then you should be in court in about a month or 2.
Wow, that's a lot quicker than the 4 to 6 months.
Right. It gets really bad, you file for an emergent application to get you on the calendar in 2 weeks. If it's yeah. Now,
what would be really bad? Do you have any examples of something that was really bad?
The flooding the property one.
Flooding, like literally, like water.
They intentionally, they turned on sinks in the basement, and they are purposely letting it flood.
Wow.
Right. Now, again, there's a list. If you look in the Anti-Eviction Act, I think it's clause 61.1. That'll list all your grounds. But the other one that you see most often, and this one parlays into the real estate practice, is you get situations where the landlord's like, I have a month-to-month tenant, and I'm selling my property. I'd like to terminate them because I'm selling. Okay? And that's also not totally allowed, right?
Wow.
What's interesting here is, first of all, if your tenant's on a written lease, that written lease trumps everything. Okay? So that tenant, if you were, my advice to landlords is, if you are thinking about selling that property, keep them on a month to month. Right?
Makes sense.
Because if they have a lease that now expires in April of 2024, you can't sell to someone who wants to move in. You're going to have to buy them out of that lease if you want them out.
Wow.
Right. Now, let's say they are on a month to month. There is a clause in there, it's called the owner occupancy clause, that if you are selling to a buyer who is personally certifying in the contract that they intend to personally occupy the premises as their primary residence, you can terminate a month-to-month tenant on 2 full calendar months' notice. So, let's say, Santiago, I own the property. I have this month-to-month tenant. I'm going to sell it to you. All right? Today is July 18th. We go under contract. In that realtor contract, paragraph 43, the attorney should be savvy enough to know, include a clause in there that says buyer intends to personally occupy this property after closing. It's July 18th, 2 full calendar months, end of August, end of September. I can then, once we are officially, only after we're under contract, I serve a notice to quit terminating the tenancy September 30th. And then if the tenant doesn't leave on October 1st, you could file for eviction, and if it's going to blow up your real estate deal, you could file for an emergent motion to get it heard quicker.
Whoa.
Okay. That also,
Interesting.
yep, that owner occupancy clause also comes into effect sometimes where you have an owner who wants to move back into their property, right? They say, listen, for whatever reason, I moved out of state for X amount of years. I'm back in Jersey now. I need to move back home. Okay.
Mhm.
Now I get this phone call all the time. I get disgruntled landlords who are like, they live with their wife in one town, and they're like, listen, can I just say I'm going to move back into the condo? And I'm like, are you
To get him out.
getting divorced? No. You leaving your wife? No. Okay. So you can't do that because there are serious penalties for lying. Because I've actually taken the case. I've represented tenants who who left because their landlord told them that they were
moving back.
Yeah. And then they drove by the property. We found out that they didn't personally occupy them, and we sued it. We got a significant judgment as a result of it.
Wow.
Right. And there could
I'm sure it happens all the time. Right?
It does. And, I like to consider myself a pretty straightforward, honest lawyer. If my clients are contemplating doing it, I tell them, just don't do it. Don't play around.
Yeah. Sure.
So those are what we see as some of the more common grounds to evict a tenant. You'll also see convictions of drug dealing, stuff like that.
Right.
That could get you a quick notice to quit. And there's a list of other grounds as well that we don't have to go into anymore on this particular call. So,
Gotcha.
Right. So now so far we've covered the non-payment case, which remember is no notice. We've covered your notice cases. And if you try to do it on your own and try to interpret the statute, it's so hard to really understand what is and what isn't a notice case, because it's like it lists the grounds for eviction, and then like 8 sections later in the statute, it lists the notice requirements and cross-references each subsection. So you got to really know the law in terms of knowing what notice is required. And if you don't serve the notice properly, and if your notice doesn't reference the proper grounds for eviction and doesn't properly reference the clauses in the lease and doesn't give the correct dates and doesn't properly list the conduct and doesn't properly tell the tenant what behavior needs to stop, you can go file the entire complaint and the judge dismisses it, saying the court lacks jurisdiction because your notices are inadequate and you are starting over.
Wow. Thank you very much for that, because that leads me to my next question, which was, what are some areas where you've seen landlords lose evictions or get delays or fines for not doing things correctly? I would say that's...
Right. All right. So that parlays nicely into the next two categories, which is preventing delays or fines, and then, attorney versus DIY, right? So let's talk about attorney versus DIY. Number one is if your property is owned by a commercial entity, you have to have an attorney. That's law in New Jersey. You cannot a corporate entity cannot represent itself in court. So at that point, I've had cases where Jane Doe represented the plaintiff landlord, and it turns out it was owned by ABC, right? So we have to file an amended complaint and refile it. But the proper thing to do, corporate entity, go seek counsel, go get your attorney, and hopefully, he or she will know the proper way to file. Now, let's say you're an individual who owns a property. Can you, and your lease doesn't contain that magic language that allows you to recover attorney's fees, and now you're really hard pressed for cash. You can't make your mortgage payments on your property because, trust me, there are certainly plenty of landlords, especially after COVID, who are suffering like that,
right?
And they want to save the money. If that's the case, could a landlord represent herself in court without an attorney on a non-payment case? Probably. I mean, if it gets to the point where the tenant's challenging habitability issues, at that point, you might want an attorney. But sometimes attorneys are reluctant. I don't usually like to save pro se's cases. I get someone who filed it on their own, and now I got to go undo a whole pile of mistakes that they made, and it's a waste of my time. I can't save cases, so I don't love doing that. So, with the rare exception, my advice is probably to get an attorney, and definitely on one of those notice grounds, because those notice grounds, I'm not sure I've ever seen a party without the help of an attorney get the notices right.
Interesting. Yeah, I was going to ask you, what are the most common mistakes that you see people making, doing it themselves?
Just the notice is wrong. The notice is wrong, right? Like, you don't properly reference the statute. Again, what I see most often is the notice just saying you're terminated next month because I feel like it. And as we talked about at the beginning of this, you can't do that.
Yes.
So we strongly recommend attorneys for any eviction case, except maybe the simplest non-payment case. Okay. Now,
good to know.
Let's talk about other things that can go. Other things that I've seen in my cases where they just go a little bit off the rails. Okay.
Right.
One thing that comes up is sometimes the tenants declare bankruptcy.
Right. Chapter 7 or...
to be honest with you, I am not 3. A bankruptcy attorney.
Right. Okay.
Right? But in the landlord-tenant context, I've had to navigate my way through bankruptcy court a little bit, because what happens is the second they file for bankruptcy, the case is dismissed without prejudice pursuant to this. There's an automatic stay in bankruptcy.
Wow.
Okay. Now, sometimes the tenants are bankrupt. A lot of times the tenants do it as a stalling game. If you go back and you look at the record, they filed for bankruptcy a couple of times. Sometimes that bankruptcy gets dismissed 3 months later, because once the bankruptcy starts after the bankruptcy petition, that tenant's required to start paying their rent in order to keep the bankruptcy going. And a lot of the times the tenants don't pay the rent, and then I have to go to court. I file a motion to vacate the stay and say, can I have permission now to proceed? The tenant's not complying with the terms of the bankruptcy. So, right. So that's one thing that's kind of, that gets a little bit murky.
Yeah, definitely. I can see that happening.
Look,
what about, sorry, go ahead.
No, you ask. Go.
No, I was going to say, as far as like record keeping, I'm assuming some of these landlords may not be that diligent when it comes to keeping evidence and documents that they may need later down the process, down the line in the lawsuit or eviction.
The aptitude of my landlord clients ranges from all the way over here to all the way over here, man. I mean, I've got ones who keep perfect books, perfect ledgers, everything's crystal clear. And then I got landlords who send me different ledgers for the same tenant. And I'm like, you gotta figure it out what it is. You have to. Because ultimately that ledger is a piece of evidence that the landlord needs to swear to and authenticate in court if we're going to try this case. Right. So you got to have good bookkeeping. And the reality is a landlord who's good at tracking and good at what they do. And I usually know the difference with my clients. A landlord who's good at that is usually going to have a much easier time and waste a lot less time trying to secure judgment.
Right. From what I hear, a lot of our members here at DoorLoop that use property management software, seems like whenever they have a situation like this, an eviction, they say it's like a click away. It's like they already have everything ready to go. Right.
That's what you want. People have rent payment portals where all that stuff. It's a lot easier in that regard. And look, again, I've been speaking so much through the landlord perspective, but I represent tenants too. I've got a tenant trial on Thursday where the tenant didn't pay 3 months of rent because she said I had to pay for so many exterminators because there was crickets, bees, and fleas. And and rodents go through entry points, and
Oh
and
my gosh.
and every exterminator they hired laid traps and sprayed poison, but never actually sealed all the open vents. And it wasn't until I hired my own exterminator that they were like, "Oh, by the way, none of this stuff works if you don't actually seal the opening." So
Yeah, with caulking, right? And expanding foam, I'm assuming, or
all
somehow.
different. Depends where the hole is. But the point is, so I represent both. It's just in general, you see it. You get more landlords calling because, again, I hate to say it. It sounds wrong to say, but if a tenant has not paid the rent, odds are they're not paying your legal fee,
Good
right?
point. Yeah.
Unfortunately, as much as maybe in my later years when I retire, I'll have the luxury of doing more pro bono work. But at this point, I have a practice to run, and
Right.
you gotta take paying clients with some
Right.
exception. Yeah.
Right. And like I've seen some of my lease agreements, and one of the pages said, it was a line that said that I was responsible for paying any kind of attorney fees. Like the wording was really discouraging for me to seek legal assistance.
Yeah.
So,
Yep. Well, recently the law changed where if the landlord requires you to pay the landlord's legal fees, landlord has to pay the tenants. It's now reciprocal, so
oh, okay.
it's a shared risk if you're going to include a fee shifting clause. But
Gotcha.
so there's some other stuff that's changed as well, and this was kind of more with the rise of COVID. Sorry,
Uh-huh.
let me go back a minute in terms of the tenants. There are also, if
Sure.
they are a certain income level, there are a lot of agencies that provide awesome services. Like there are some legal aid in New Jersey that their landlord-tenant attorneys are phenomenal, and they know every single law inside and out, and they know every nuance to make sure to get your case tossed if it's not done perfectly.
Nice.
So
Good to know.
yeah, they do. They're good. They're really good. And you know what? We tell tenants all the time, just give them a call and hopefully you qualify. Now, some other things that we have seen um, with mainly like started a lot with COVID is our rental assistance applications.
Uh-huh.
And that's been something that we've had to help with a lot of our landlord clients with, and tenants as well when they're trying to get the money.
Okay.
What initially happened, this is like the short long version.
Uh-huh.
Initially, right after COVID started, Governor Murphy signed an eviction moratorium that just froze evictions. And
Right.
there was a need for it. There was going to be no public lockouts. What ultimately happened, that moratorium stayed in effect for all of 2020 and all of 2021, subject to certain limitations, right? If you were
Right.
below a certain median income level, you could not be locked out for any debt. I think it was before August of 2021. And then if you were even lower than that, it was December of 2020. So let's say you were being locked out, you were getting evicted in April of 2022. The landlord, if you certified that you fell within that category, the landlord could only evict you for the rent owed in 2022. It
Oh,
didn't mean that the tenant didn't still owe it in a future collection case,
right.
but the landlord could not lock out based on those grounds. Now, here we are a couple of years later. The moratoriums are all lifted, and the landlords, are locking out or filing for evictions based on more recently incurred rent. But what we're seeing now is a lot more assistance from the Department of Community Affairs. And the DCA there's a whole list of documents the tenant needs to submit, but then the landlord needs to cooperate. And if the landlord doesn't cooperate in filling out the forms and getting the documents, the tenant can go to court and say, listen, the landlord's not cooperating either, and the court might adjourn the case to give them more time. At which point, If the DCA comes up with the full balance owed,
Mm.
they pay it, landlord keeps it, tenant stays. If
Wow.
if it's less than the full amount or it's close to the full amount, I've seen cases where the landlord takes it and you still can't lock them out. The landlord takes what they could get from it, reserves the right to pursue other claims. But the landlord can, if they want, they can reject it. And at which point you'll probably end up back in court and the tenant will say, DCA paid it. And the landlord will have to say, I don't want partial payment. I'm not taking partial payment. And then you could still probably get a lockout. I haven't seen that yet. And it's just, I don't have a clear answer on it because from my experience, different counties are handling that different.
Right. That makes sense.
Right. So the other big change that we saw post-COVID is the county started implementing a mandatory case management conference on Zoom. It used to be you filed for eviction, you got your court date, you showed up in court. They now started adding this Zoom hearing where you see like a specialist who tries to just kind of flush out the issues and say, okay, how much rent is owed? They talk to the tenant. I think what people ended up realizing, number one, most of the tenants were not attending these conferences. Number two, I'm not sure they resolved anything. Because, okay, you go, tenant, how much you owe? I owe $10,000. Okay, do you have the money? No. Okay, we'll see you in court in 2 weeks. So
this is okay, right? It's like another step.
Right, it's just adding a step. So I think what you're seeing now is I think those case management conferences might start to go by the wayside. But we'll see. So it's gonna eliminate one of the steps. I mean, I don't mind the case management conferences. They're on Zoom and you at least get a chance to put a name. Sometimes you'll see, like, you'll meet the tenant or you meet the landlord and they'll say, all right, they're not bad, or they're, they don't seem like they're honest. You kind of get an impression, get a better idea of what you're going to need to do at trial.
That makes sense. That makes that possible. Wow, thank you so much for mentioning that. All those changes after COVID, it's made me go back. I can't believe it's been 3 years.
Crazy, right?
Crazy, because that's when I was telling you I used to live in Hoboken. That's when I left. But that's a different story. Going back a little bit about people, property owners doing their own evictions. So it is possible. You mentioned that it can be a little risky. Oh, not if you're right. Not if you're corporately, like a corporate that owns the properties, correct?
Yep.
Now, for property owners who are not corporate, how much would that normally cost? And time, how much time would it take as well? An average.
That's a good question. Sometimes a lot of it depends. Like if you have a client that's a management company that, or a real estate holding company that operates a large building and they file evictions, a lot of them, right? You just do them in bulk. There's usually you're looking at, there's about $60 in filing fees. To get a warrant or removal is about $30. So you're looking at about a total of around $100 in court costs. So sometimes let's see, $500 per filing. But if you're representing the individual owner of a house or something like that, it's usually about $1,000 to $1,250 for a case. And it could be more if I have to, and that does not include, if I have to try the case on habitability, that trial could be half a day to an entire day. There could be 5 witnesses on habitability and a full trial prep. I mean, yes, it's a trial in the landlord-tenant part, but you've got to get all your evidence onto the record and treat it like a real trial. So,
right.
But the average case, let's say around $1,000 to $1,250, and depending on the notice, and if it's a notice grounds, maybe $1,000 to $1,500 because you got to do a bunch of those notices, and they just take time. They take time. The file sits open for a while, and you gotta especially now with these rental assistance applications. You got to walk a lot of the landlords through it. So that's usually just a best estimate.
Gotcha. And time-wise, would you say 3, 6, 9 months, a year, or on average, how long for when people do it themselves?
Not famous case. So one thing we forgot to mention is the COVID the biggest thing that came out of COVID were the backlogs.
Right.
Right. The backlogs really, like, they tied the court up, for about 1.5 years. And now the courts are about even. Most of the counties, like I'm in Middlesex County, where, they're more of a higher volume vicinage. But you're looking at Middlesex, Essex, Hudson. They're now pretty much caught up. But some of the more suburban or rural counties were caught up, almost a year ago.
Gotcha.
Now that they're back on schedule, I mean, you're probably looking at, it used to be a 4 to 6 week window. That's probably about right again.
Oh, okay.
So
everything's kind of...
Again, but that's a non-payment case. If you go to a notice grounds and you got to serve all your notices, 4 to 6 months.
Gotcha. If they do everything correctly, below the notices.
Yep.
Right. If they don't, let's talk a little bit about fines. Is there any kind of fine that people who try to do it themselves get more often than they wish for not doing things correctly?
No, I haven't seen a situation where the landlord got fined. There can be instances where the property is not actually, doesn't have a certificate of occupancy. In that case, the landlord should be penalized, fined, pay for 6 months of tenant's relocation. But just on a misfiling, you don't see the landlord usually get fined for it.
Oh, gotcha. For like the process.
Yep.
Amazing. Thank you. Thank you so much, Greg. Another question. Tell us a little bit about squatters' rights laws in New Jersey. Do you deal with those often, with those kind of situations, or not so much?
Yeah, so, one of the first hurdles you face is trying to define whether the person's a squatter or not, right?
Right.
A lot of times they're like, okay, well, this person was my boyfriend and we broke up, and they, used to pay $1,000 towards my expenses. Well, they may be a tenant, right? So, paying rent, there doesn't necessarily have to be a lease agreement. So the biggest difference is if you have a squatter or an occupant who is not defined as a tenant at the property, the method is similar, but you don't file a complaint for eviction in the landlord-tenant part. You file a complaint for ejectment in the special civil part. So the wording is similar, but it's not about rent that's owed. And the squatter's main defense usually is, I'm a tenant, right? I have rights as a tenant. I've been paying rent. But that's really the only difference. I've done a bunch of ejectment cases off the, stuff that we've been talking about. I know off the top of my head. I don't actually off the top of my head remember the exact tests for what determines someone to be a tenant versus an occupant.
Squat. Got it.
Yep.
Got it. Thank you. And how about rent increase laws in New Jersey? Is that something that comes up often?
Yeah, that's a hot button issue. Now, as a general rule, none of the statutes that I referenced, Anti-Eviction Act, Truth in Renting, Security Deposit Law, Abandoned Property Law, those 4 big ones with respect to the landlord-tenant relationship, they do not establish an amount or a percentage on which the landlord is allowed to increase the rent. Okay? There's no set statute. The first place that you have to look is whether the municipality contains a rent control ordinance. And if the municipality has a rent control ordinance, that's your limit, right? And most of the municipalities that have them, you're going to see them more in your urban areas, not so much in your suburban or rural areas. But in the areas that have them, you usually see around 2.5% to 3%, right? That's usually your cap. And if you want to exceed that, you have to make application to the rent control board for why your expenses have gone up, or you need a real estate appraisal for why the rental values, you haven't raised the rent in 5 years, blah, blah, blah. Now, let's say there is no rent control ordinance. It goes under the common law rule of unconscionability. Does the amount that you're seeking to increase the rent shock the conscience? Okay? Right? As there is no general percentage rule on that. And what will happen is, let's say the landlord wants to raise the rent. Okay?
Right.
I want to raise the rent, Santiago. The average landlord will, on 30 days notice, say starting September 1st, your rent goes up from $1,500 to $2,000. Okay? First of all, not the right way to do it. What you need to do is you actually need to serve a notice to quit that says your existing tenancy is a month to month and your tenancy ends on August 31st, 2023. You have to move out by that date unless you agree to stay with the new rental amount of $2,000, in which case you are being offered a new month-to-month lease. Okay?
Makes sense.
Right? So you can't just send them a letter. It has to be the proper notice to quit to raise the rent. Now, you get that letter and you're like, this is bullshit. Like, you can't raise my rent $500, right?
Right.
Sorry about the...
No worries.
So, you can't raise my rent $500. So what do? You stay on September 1st. You pay $1,500 that month. Landlord's like, you're $500 short. You're like, nah, I'm going to ignore this guy. October 1st, you pay another $1,500. You're $500 short. Ignore him. Now the landlord takes you to court for non-payment of rent, saying, Santiago owes me $1,000 for the last 2 months he's been shorting the rent. I sent him the notice. He stayed and thereby agreed to pay the new rent. Okay? The judge will ultimately determine whether or not the rent increase was unconscionable. And the judge may say, listen, Santiago, he could have raised you $200. We don't think $500 is allowed. You owe $200 for the last 2 months. You owe the landlord $400. Pay it or leave.
Very interesting.
Right. So there can be a hearing on unconscionability. So when I get a tenant who calls me up and says, hey, is my landlord allowed to jack it up this much? I say, well, all right, is there rent control? No, there's no rent control. All right, how much is the increase? When was the last time they increased? And are they giving you any additional services? Because let's be honest, everyone's loving hiding behind the guise of inflation right now.
Yeah.
Everyone's like, $1,500, overcharge $2,000 now because I can. I don't think it's going to work. So in general, I think when you're dealing with that, I think you're looking at, as a general rule, you're probably looking at 5% is okay. 10 is probably the limit if you can show why it's going up that much. So my advice for landlords who are unhappy with their rent amount is to incrementally increase it every year, right? You got it. If you're at $1,500 and you think the market is at $2,000, get them up to $1,700, then to $1,850, then to $2,000. Like it's going to take you a little time to do it the right way.
Makes sense. Thank you. Thank you so much for that. I'm sure all our members and everybody watching this from New Jersey or not is definitely finding a lot of value in that information, Craig. I think we've covered everything in the agenda, but are there any final thoughts, any other ideas or information you would like to share with property owners or property managers, landlords from New Jersey?
Yeah, we'll do the. Let's talk about 3 things. Number 1 would be truth in renting. If you're gonna do a lease, just do us all a favor and don't get one on Google, and then when you're in court wondering why you can't charge late fees, legal fees, and the tenant's lawyer has you in big trouble, you'll know why. Have an attorney do a proper lease that contains all the things that are required by the Truth in Renting Act, window guard notifications, Megan's Law stuff. You want that stuff in there. That's number 1. Number two, security deposits. I see landlords screw this up all the time. Within 30 days, the landlord is required to deposit your security deposit in an interest-bearing account with your name on it, in a separate account for each tenant, a separate sub-account. The tenant should receive written notification of that deposit within 30 days. And if you don't do it, the tenant is allowed to apply the security deposit to rent if they miss a month, and you can't ask for that deposit. And that really screws you on the back end when the tenant's left the place a mess, and now you don't have any deposit anymore. Okay, so that's number two, right? So know your security deposit law. You can Google New Jersey security deposit law. You'll understand enough of it to make sure you get it right. If not, you call my office anytime. And then the last thing is the abandoned property letter. When the tenant leaves, you get the lockout. You can't just throw their stuff out. You can't it doesn't work like that. So you actually have to send the tenant a letter to their last known address, which may be the address that you locked them out of because you don't have a forwarding address. I try to get their emails. I do everything I can to just say, listen, here's our letter. You've been locked out. You have, I think it's 30 days from receipt or 33 days from the date of mailing, whichever is later, to contact the landlord and reclaim your personal property. In the meantime, the landlord may move everything to storage, but the landlord has to keep it safe. Landlord can throw out perishables. So that's the other thing. If you overstay, let's say you agree to leave on July 31st in a consent agreement. You say, oh, okay, Craig, I'll leave. You overstay on August 1st. I file for a lockout. It takes about 7 to 10 days to get the sheriff to lock you out. It's now August 10th. I now have to go in there, keep all your stuff in storage or move it somewhere. That place may not be rental ready for another month or two.
Right.
But you have to comply with it. So when we do consent to vacate agreements, I include a clause in there that says any property left behind will be deemed abandoned, and landlord is not required to comply with the abandoned property law. So at least on that day, if the landlord wants to get a dumpster, he could go get a dumpster.
Got it. Great to know.
Make sense?
Yes, sir. Thank you, Craig. So much valuable information. Thank you. Really, thank you so much. Craig, last few questions. How can someone hire you? I know your contact information. I'm going to show it in just a couple of minutes. But how can someone hire you, and what are your typical rates that someone can expect?
Well, I was telling you my general rates before, for if you're looking for a client that owns a lot of properties, we usually do a reduced rate on filings. And if you have an individual client, it's usually a little bit more, for an individual client, usually in the ballpark of $1,000 to $1,250 on a non-payment case. If the court eliminates one of the appearances, that fee may go down a little bit again, because part of the increases were the additional appearance that was required. And of course, inflation, that, remember? Right?
You got to put that in.
So that's the general idea. And then we bill, again, one of the biggest problems that I've come across with representing tenants is that a lot of times the tenant's issues can be resolved with a phone call with the attorney. So the tenant says, okay, I don't have heat. What can I do? I have to get on the phone with them for half an hour and then finally just say, listen, you can repair and deduct, or you can withhold your rent, put them on notice. And at that point, I've spent a half an hour on a consultation with a client that I can't bill. So, so I had mixed thoughts on this, but what we started doing is we charge a nominal consultation fee. So we'll we'll spend 20 minutes with a tenant for about $125 consultation fee, because a lot of times the tenant doesn't actually need to hire me. They just need some advice. So when that situation arises, we do that as well. But we represent landlords and tenants both. A lot of it just depends on what the needs are. If you call my office, I'm in downtown New Brunswick. I go all over the state. I have one as far as Cumberland County, which is 2 hours south, and I take them as far north as Bergen County or Hudson. So on some cases, if it's not practical, I'll refer you to a colleague who's got a closer office. But my office is just me and my assistant, Camille, who is fantastic, who will perform your intake, get all the information from you, and then we can have a phone call to see what your needs are, and be happy to speak with anyone about these issues. But I also have other practice areas as well: residential, commercial real estate,
Right.
personal injury, litigation. So if you have any questions, hopefully feel free to reach out to me.
Fantastic. Great to know. And I have it on the screen, but can you remind us of your email and your telephone number so people can...
Sure. My email is Craig, Craig, at Rothenberg.com, Rothenberg.com. Phone number at the office is 732-247-5002. My assistant's name is Camille. So if you ever call the office, say, I watched this DoorLoop presentation and this recording told me to call the office, and I want to talk to Craig, and I'd be happy to jump on the phone with you.
Fantastic. Craig, thank you very, very much for your time. I really appreciate you taking the time today to talk to us, and I'm sure all our members and everyone who watches this, even if they're not from New Jersey, I'm sure they will find a lot of value in it that they can apply. And just thank you very much, Craig. Is there any final thoughts? Anything else you'd like to mention before we go?
No, I'm honored to be selected to give the presentation, and happy to answer any questions anyone might have. So thank you very much.
All right. Once again, thank you very much for joining us today. And remember, if you're a landlord or a property manager and you haven't tried DoorLoop yet, go ahead and request a demo today. You can do that on our website at www.doorloop.com. Okay? Once again, thank you very much for joining us today, and we'll see you on the next one.